Hello everyone, welcome back to the Mystery Channel 33. I am Tatiana. I'm here to help solve more missing women, children, and men cases. I'm here to break the codes if I see any. I'm here to see where their bodies are located if they know. And I'm also here to see if they're alive, deceased, body, suited, change ethnicity, or misidentity. You already should know who's involved, so let's begin. This is titled Court Overturns Death Sentence in 1987 Execution Style Yuma Murder. Okay, this is him. I remember this happening. Okay, this is Theodore Washington. Okay, no, that's not him. Okay, that was an immigrant from four color girls. But when I did the research on this like 2 weeks ago, I can only find these two guys right here. Okay, but now when I looked again yesterday, it was not. It didn't have it no more. So I'm glad I screenshot these pictures. So it could be him, cause Starlene, okay, or it could be this other one right here. Okay, and now they done took these pictures off. Okay, so let's begin. A federal appeals court Wednesday overturned the death sentence for Theodore Washington, the last of three defendants still on death row in 1987 execution-style murder of Starlene Hill during a distractingly violent home invasion in Yuma. True. A divided three-judge panel of the Ninth U.S. Circuit Court of Appeals found that Washington's trial attorney failed to present evidence of his client's diffuse brain damage and his history of substance abuse and other problems that might have rated against the death penalty. Basically, all of them are dead, okay, deceased. All of these, even the one they saying, even Theodore that they saying he dead, he is deceased as well, okay, yes, okay. Kind of like that, okay? It did happen around that time, okay? So, yes, I just wanted to get this out, okay? Yes. This raises a reasonable probability that had the court been presented with the mitigation evidence the first instance, the outcome would have been different. Judge Warner Gold wrote in the opinion for the court, which ordered a new sentencing hearing for Washington. But Judge Consuelo Cahan dissented, writing that there is no good reason to second-guess the trial judge in the case, and adding that the only injustices are unwarranted interference in the case. Lawyers in the case did not immediately respond to a request for comment on Wednesday's ruling, the most recent in years of appeals by Washington. The case began on the night of June 8, 1987, when two men forced their way into the Yuma home of Ralph and Starlene Hill, looking for the Hill's daughter, who had left her common-law husband and returned to her parents' house. Yes, I think she did do that, Shanice, okay? Back in the day. The Hills were bound and forced to lie face down on their bedroom floor while the men ransacked the house, demanding drugs or money and intimately twisting a pistol in Ralph Hill's ear, according to court documents, or charade, but it was either one of them two, okay? At some point, the men shot Ralph Hill in the back of the head with a shotgun, reloaded, and then shot Starlene execution style. True. She died, but Ralph Hill survived with serious wounds. Fred Robinson, Susan Hill's common-law husband, was arrested shortly after the attack, and Washington and Jimmy Mathers was arrested soon thereafter. Each of the men was charged with 6 counts, including murder, attempted murder, assault, burglary, and armed robbery. Yes, the three were tried together in December 1987 during the home invasion. Okay, yes, that's reverse psychology. Yes, doing that. Okay, that is the trial. All three was convicted on 6 counts and was all sentenced in January 1988 to death row. True. Okay, this him again. Okay. The Arizona Supreme Court vacated Mathers' convictions for insignificant evidence, but upheld Washington and Robinson's convictions. The two appealed but had their convictions and sentences upheld by Superior Court Judge Stuart Bradshaw, the same judge who presided at their trials and sentencing. Yes, in a subsequent appeal, however, the Ninth Circuit vacated Robinson's death sentence, agreeing with his argument that his trial attorney had utterly failed to mount a defense in the sentencing phase of his trial. Okay? Not really. Gold said the ruling in Robinson's, well, they didn't want that. Ruling in Robinson's case, which we can do that, cast a long shadow over Washington. That's how we used to do it anyway. We still do it. Okay? Well, and they do it too, yeah. If it don't make sense, but the same thing, who made a similar argument among others on the latest appeal. Washington said that his attorney properly investigated his past. It would have shown that he suffered daily whippings as a child, was sedated with alcohol, and later became an alcoholic, had a cocaine problem, and a low IQ, all of which could have argued against the death penalty. Okay, talking about me, okay? The record here amply demonstrates that defense attorney Robert Clarkey's representation of Washington at the penalty phase was objectively unreasonable and deficient. Gold wrote, Gold said Bradshaw committed precisely the same error with Washington as he did in Robertson's case, and that there was a good chance he would have ruled differently if he had all the facts about Washington's past. The court sent the case back with orders for a new sentencing hearing, or if not, for the state to change Washington's sentence to life in prison. But Kylan said that Bradford did have the evidence he needed and was in the best position to rule. Okay? There is no good reason for us to dismiss Judge Bradshaw's conclusion from our lofty push 25 years later. Amen. Kahan wrote. She said Washington's claim of an effective defense presents no basis for vacating his sentence. Kahan also said there is a temptation to bend the governing legal standards to equalize the outcomes, because Mathis had his conviction overturned and Robertson had his death sentence vacated. However, enticing the impulse, that is not our role, she said. Ours is the duty to apply the law to determine whether Washington has met his high burden of showing a constitutional violation that deprived him of a fair trial. He has not, Kahan said, okay? And that is the case of the execution style of the four, okay? If you like to help with this case, you can. I don't do this for the fame or the money. I do it because it's what I love to do. And to the real families of these victims, corporate America will set you up. Thank you, peace, and be safe.